Michigan State Supreme Court says the repeal of the emergency manager law can now be on the November ballot. Here's what happens next here. The Board of State Canvassers can certify stand up for democracy's petition for the ballot. And once that happens, Public Act 4 or the emergency manager law will be suspended until the November 6th election. And the law will revert back to the previous emergency manager law, from 1990. 7 Action News reporter Smitha Kaloki begins our coverage from Detroit.
The Supreme Court did not rule on the merits of Public Act 4. Instead, it ruled on a technicality over the font size regarding some petitions. But still, that decision will have wide-reaching consequences. With the Supreme Court ruling, there is an air of uncertainty.
The Supreme Court has passed a judgment, and we're going to adhere and respect that judgment.
But what that law will say remains to be seen. The 4-3 Supreme Court ruling says voters will get to decide if Public Act 4 should be repealed. Public Act 4 handed Governor Snyder and emergency managers significant powers to deal with struggling schools and cities, including Detroit Public Schools, and through a consent agreement, the city of Detroit. Through that consent agreement, Mayor Dave Bing doled out union contracts, which included sizable cuts without negotiations. Pending the November vote, the city is working on a backup plan in case those contracts are voided.
We've been working on a double plan for some time. So once again, we know what we need to fix, and we've just got to make sure we keep our focus and doing the things that needs to be done to fix the city.
What that means that the bargaining table, it means that those folks who were entrusted with that authority are the ones we're going to deal with, and not a person who's going to be here today and gone tomorrow.
Even before the November vote, unions have declared this a victory, along with the organization Stand Up for Democracy, which submitted more than 200,000 signatures to get the question on the ballot.
Had volunteers collecting signatures in every county in the state, and that is some broad-based, deep support that's going to turn out and repeal this law in November.
Once the Board of Canvassers signs off on the petitions, the question will be put to voters on the November 6th ballot. From Detroit, Smitha Kaloki, 7 Action News.
State Treasurer Andy Dillon, who helped Governor Snyder select emergency managers for cities and schools, spoke out about the High Court's decision this afternoon and what it means to cities with current emergency managers who will now become emergency financial managers.
The process for appointing EFMs is a little bit different than it was for emergency managers. And it's also a little bit different between cities and school districts. As it relates to cities, we've anticipated this event, and for 3 of the 4 cities, the current emergency managers will be reappointed as emergency financial managers.
The city of Flint, by the way, is the only one where the governor and state treasurer are still working to appoint an emergency financial officer. Governor Snyder issued a statement on the ruling saying he fully supports the rights of all citizens to express their views. Now, at the same time, he says suspension of Public Act 4 may, quote, adversely affect Michigan communities and school districts mired in financial emergencies. The governor goes on to say it, meaning the suspension of Public Act 4, promises to make eventual solutions to those emergencies more painful.
And here are a few more details now on Michigan's emergency manager law. The whole process began back in 1988 when the city of Hamtramck had severe financial problems and needed help. Then in 1990, the law was strengthened to provide emergency financial managers for cities or school districts to oversee money problems. Last year, Governor Snyder signed a new emergency manager law where he could appoint an emergency manager to run cities or schools. These managers have the power to cut spending, sell assets, and get rid of union contracts.